Welcome to you all to what is, I think, part 4 of our Brexit webinar series, Immigration After Brexit. Welcome particularly to our friends in the Danish UK Association, which has kindly linked this event in their calendar. So a very warm welcome to them and to you all. And for those of you who don't know me, my name is Tim Hayes. I'm a legal director in the immigration team in BDB Pitmans, and we specialise in immigration for businesses, or helping businesses to bring workers into the UK under the business sponsorship routes, and also personal immigration, so be that family visas or citizenship, etc., etc. But what I will be focusing on in this session is how the immigration rules have changed over the last year since Brexit has happened, and the impact of those changes on EU nationals. And I'll be focusing on sponsorship primarily under the skilled worker route, because that's really going to be the main route, I think, for how EU nationals are going to access the UK for work purposes going forward. And we'll also look at some of the other categories that might be relevant for EU nationals if the skilled worker route doesn't work out, or you want to consider other options for working in the UK. So obviously I'm on my own today, but I will try and monitor the questions that come in. If you want to use the Q&A function down at the bottom of your screen to ask questions, I'll try as best I can to pick them up towards the end of the session, obviously depending on how much time we have. There's quite a few areas to get through to sort of take you through the changes for EU nationals as they look to come to the UK, but hopefully we'll cover off all the main areas as best we can. And it's been quite a tumultuous year or 2 years really in terms of immigration. I guess what once had been so easy under the principles of free movement for people to sort of move around the EU, from the UK to the EU, and vice versa, for the purposes of work, has become a fair bit more complicated for those who don't already live, or weren't already living in the UK as of the end of 2020. And so what we will do is jump straight onto the next slide. Melissa, if you can move on to the next slide. So let's look at the position of EA nationals, European Union nationals, who are currently in the UK at the moment. Obviously, I'm sure many of you will be aware of the EU settlement scheme, which is a scheme that was brought in by the government a few years ago, in order to allow EU nationals resident in the UK by the end of last year to safeguard their rights in the UK. And it's kind of a semi-automated system. Many of you may have already even been through the process yourselves of applying. It's a very simplified application procedure, and really all that applicants need to do is to show some kind of evidence that they were resident in the UK before the 31st of December 2020. And if they were resident here for at least 5 years, they would be granted what's called settled status. And if they were resident for a period that is less than 5 years, then they would be granted what's called pre-settled status. And often, if an EEA national is working in the UK, the automated system will pick up records of having paid tax in the UK, and a decision will come through actually very quickly. Obviously, there are instances where decisions are going to take longer because people's situation is more complex, and the system might not be able to pick up tax records, things like that, and actually further documentation may need to be provided, and it can take up to a period of months to get decisions back in certain cases. But the big takeaway is that this scheme will be ending on the 30th of June 2021. So that's the deadline for EEA nationals to apply under the scheme in order to safeguard their rights and to be granted settled status or pre-settled status. And if you know the EEA nationals who are in the situation where they haven't applied or potentially colleagues or employees of yours, then they really need to get cracking on that application, because it's incredibly important to get it in before the 30th of June. The Home Office has said that late applications will be considered, but that it's likely that actually in order to accept late applications, it's going to be in a fairly reduced number of instances. And actually the settlement scheme guidance does sort of talk about when, what kind of instances they will accept people making late applications in, and it's instances where there are reasonable grounds for the application having been made late, and they're quite compelling in exceptional circumstances. So it's best not to have to rely on that concession and get the application in as soon as you can. So during this grace period up until the 1st of July, I'm sure many of you will have heard the government referring to the hostile environment, which applies otherwise to non-UK nationals who are not in the UK legally or have no right to be in the UK. That hostile environment is effectively suspended until the 1st of July during that grace period, and thereafter EEA nationals will have to have their right to work checked in a different way. Perhaps if we can move on to the next slide. Just focusing on right to work checks, and this is important if you're an employer of EU nationals. So during this grace period, up until the 30th of June, you can continue to accept the passport and national identity card of EU nationals. So the right to work check is going to remain unchanged, and that's going to be evidence of their permission to work. And you won't need to differentiate between European nationals who have arrived in the UK after the 1st of January 2021 and those who were already living here before that date, which obviously carries a risk that you may inadvertently employ someone who may not necessarily have the right to live and work in the UK. And that is a very real risk. And if you do receive knowledge, intelligence that your prospective employees or existing employees have actually no right to work, they weren't living in here, they have no right and haven't applied or been granted pre-settled or settled status, then you would need to be taking employment steps in order to terminate that employment. So there is this risk of employing those who don't have a right to work. Conversely, if lots of employers in this situation have been saying, well, what I will do is check the right to work and demand of EEA nationals that they should be producing evidence that they have applied or been granted settled status or pre-settled status. Obviously, if you're requesting documents which aren't legally necessary, then there is a risk that you're treating them differently from other categories of employee in your organization, and of course that brings with it the risk that you are discriminating against them. So up until the 30th of June, you carry on doing your right to work checks in the same way that you have been for EU nationals. So if we can move on to the next slide. As of the 1st of July, what you would be doing in order to check those who have settled status and pre-settled status is an online check via the online checking service in order to confirm that status. Now, obviously, if EEA nationals have arrived after the 1st of January, then they would need to have some other basis on which to be in the UK. That may not necessarily be one of the sponsored work routes. It may be that they have some personal basis on which to be in the UK through family relationships, but that would need to be checked. And for anyone familiar with the checking process, what you have to do is basically check off documents, depending on the situation, you know, the circumstances which your employee or prospective employee is in. So if they have pre-settled or settled status, you will be doing an online check through the online checking service. What I would recommend is that your point of departure for all sort of right to work checks is the guidance. It was updated by the Home Office on the 17th of March 2020, and that really is your starting point, I guess, for right to work checks. So if we move on to the next slide, this isn't essentially Brexit related, but given that we're on the subject of right to work checks, I will add in the slight variation to right to work checks during the COVID pandemic. The Home Office had implemented a kind of adjusted check whereby you wouldn't have to be taking in person the documents and verifying them in person because of the impossibility of doing so, because people weren't physically in the office. And when the guidance changed a few weeks ago, the Home Office reverted to saying that you have to do in-person checks. And of course, lots of employers fed back with the points that, you know, if people weren't physically in the office still, and the guidance was still to work from home until the 21st of June, then it wasn't still going to be possible to do in-person right to work checks. And the government kind of rode back on that guidance. And the current position is that until the 21st of June, you can continue to do basically a video check of people's right to work documents. And then after that, it is reverting back to in-person right to work checks. But you won't have to do those checks retrospectively for those who you've done an adjusted right to work check for during the COVID adjusted period. So let's move on to the next slide. So let's get into the weeds of how the immigration system has really changed for European nationals. And here we're talking about European nationals who don't have pre-settled or settled status and no other right to sort of be in the UK to live and work. And the main category under which EU nationals are going to come to the UK is really going to be the sponsorship route. And as I'm sure you will have heard, the government brought in this new, and I put it in inverted commas in the slide, new points-based system, which is essentially a reworking of the old Tier 2 sponsorship process. And the main category is called the skilled worker category. So prospective migrants from EU countries will have to be sponsored under the skilled worker category, and that replaces the Tier 2 general category. And that came in on the 1st of December last year. And what we have is essentially, in order to compensate for the abolition of free movement, the sponsorship system has essentially been relaxed so that employers have a wider range of jobs which they can sponsor people for, and it's essentially slightly more streamlined and easier for sponsorship to take place. So if we move on to the next slide. We can see from this slide how that relaxation has taken effect in practice. So lots of the old quirks under the old sponsorship system have either been removed or streamlined quite significantly. Now, there used to be a requirement under Tier 2 that for most roles, an employer would have to advertise the position for a certain period before offering it to a non-European, non-UK prospective sponsored worker. And it was called the resident labour market test, and it was quite a tricky test to get right. It was quite a prescriptive process that employers had to go through in order to advertise that position and come up with evidence that actually they had done so in a certain way, and that there was no one that was suitably qualified and experienced in the UK who could do a particular role. And often it could end up being a bit of a fiction. And employers would often have a fairly good idea of who it was that they had in mind, and they would simply go through the motions. And I think really the Home Office knew that. And what has been done under the new skilled worker system is to remove the resident labour market test, and the Home Office will instead be concentrating on whether a vacancy is genuine, effectively, and the recruitment practices of an employer. So it might still be important that you advertise a position, because that's proof that it's genuine. There's no requirement to do so anymore. And the Home Office, if it ever did a compliance visit on you as a sponsor, and we'll look at later on what your requirements and what your obligations are as a sponsor, they might look into your recruitment practices. There might be unscrupulous employers in the UK who are creating positions just for the purpose of facilitating entry. And I think that's what the Home Office have in mind now with that reference to genuine recruitment practices, that it's focusing on stopping employers from creating roles where they don't really exist. So there are the sponsorship system is predicated upon the issuing of certificates of sponsorship by a licensed sponsor, and we'll have a little look later on at how you go about applying for and keeping your sponsor license. But essentially, you used to have to issue either restricted or unrestricted certificates. And the old system for restricted certificates, which apply to those coming into the UK from overseas, was notoriously lengthy. It was basically a Home Office panel which would consider applications at the end of each month, and it was quite an unwieldy, lengthy process. And that's essentially been removed now. There are no more restricted certificates, so no more cap on the number of people who can come into the UK from overseas. It used to be capped at 20,700, I think the number was, broken down into a kind of monthly running cap. That's fallen away now. And what we have are just ordinary certificates of sponsorship for those who are applying from the UK, or defined certificates of sponsorship for those who are applying from overseas. So again, it's a bit of a rebranding. Essentially, it kind of fulfills the same function. It distinguishes between those who are applying from the UK and those who are applying from overseas. So for ordinary certificates, for those who are applying from within the UK, they can take an age to come through. Once you apply for those certificates, they can take 8 weeks, 12 weeks. So that could really throw a spanner in the works of your recruitment practices, but there is a way for you to apply for that application to be expedited. And if you pay the Home Office £200, you can get those certificates back within 5 working days. So that's quite a big improvement, and obviously, in my view, it's money well spent. In contrast, defined certificates, perhaps surprisingly, for those who are applying from overseas to come into the UK, which have replaced restricted certificates, similar process, but those will come through within 1 or 2 working days. And in our experience, that has generally been the case. So that is a much quicker turnaround than used to be the case with the kind of monthly panel of restricted certificates decisions which the Home Office used to make. So that's a big improvement. And I made the point there that the Home Office says this monthly cap, which I referred to on overseas nationals coming into the UK for sponsored work purposes, has been suspended. That's the language they used. So it hasn't completely been done away with. I guess there is potentially a threat in the future that it will come back in, and actually we'll see a limit on the number of applications from overseas that will be permitted under the skilled worker route. But looking back, that 20,700 limit was very, very rarely reached anyway. And given, as we come out of the COVID pandemic, the likelihood that the need for workforce for foreign workers in the UK will probably continue to increase. I think it's probably unlikely that that cap will come back in the foreseeable future. Just those final points on the slide. So we used to have specific rules. If you earned £159,600, you used to be able to access essentially an easier immigration system, but that was very rarely of relevance anyway, and that's been done away with. Given the general relaxations in the skilled worker route, there's no longer any real value in having a high earner threshold system. And also, you used to be limited in terms of the amount of shares that you could hold in your employer. I think it was 10%, and now those have also fallen away, which could be useful. If you're a European national who is perhaps looking to set up a business which you part own, it could be a useful alternative to the startup and innovator visas, which have come in. More on those later on. But it's a useful thing that those shareholding limits have been abolished. Anyone who is familiar with the sponsor management system, which is this portal between the Home Office and sponsored licensed sponsors, will no doubt be relatively frustrated, because it can be quite a glitchy system and it can be quite difficult to navigate and to undertake your duties as a sponsor via the sponsor management system. The Home Office has, I think, said that improvements to that system are going to be likely to take effect later on this year, early next year. So that's going to be something that will be very welcome. So if we just move on to the next slide. So that's we've seen what changes are afoot for employers in terms of sponsoring EU nationals who don't have the right already to live and work in the UK. Just a few words on the requirements for applicants. For example, if someone is applying from overseas, it's a relatively quick and easy application process under the skilled worker category. Generally speaking, if you go to your biometric appointment, having received a certificate of sponsorship, that's really pretty much all that you'll need to provide in a lot of situations, because you will have your employment detailed in the certificate, you'll have your salary detailed in the certificate, and provided that you provide evidence of your identity at the biometric appointment, that's really all you're going to need. But one thing that you do need to bear in mind is that you'll need to meet the English language requirement. Now, for those making an entry clearance application, so for the first time from the EU, there are various ways that you can meet it. You can either take a recognised English language test, of which there are many which are formally approved and prescribed by the immigration rules, and there are lots of testing centres throughout Europe. Or you might have done a degree in the UK, and if you have, then that can be used as evidence of your English language ability. You might have been taught a foreign degree, so a degree somewhere else in the world, but in English. And if that's certified to be the case, then by a particular process which you have to go through, then you can also meet the English language requirement. So it's often something that perhaps you don't necessarily think about when you're looking at the sponsored immigration route. You will have to meet the English language requirement. Also, as an applicant, it used to be the case that under the Tier 2 category, you could only be here for a maximum of 6 years, and then you would have to apply for settlement or leave the country. That's no longer the case. So you could be here indefinitely. I don't know why you'd want to do that, but you could be here indefinitely as a skilled worker if that's what you wanted to do. You didn't want to make the commitment to settle in the UK. So that's perhaps another relaxation of the rules. Also, there's no cooling off period. So anyone aware of the previous sponsorship system may have come across this. It used to be the case that if you had a period of sponsored work under Tier 2 and you left the UK, you would have to wait in the majority of situations for a period of 12 months before coming back into the UK under any kind of sponsored route. And that's no longer the case. unless you're an intercompany transfer migrant. Lastly, for applicants, it's much easier to switch, and this is a real benefit of the new immigration rules post-Brexit, is that if you are in the UK, and this obviously applies to EU nationals and everyone, if you are in the UK on a different immigration category, you can now switch in the vast majority of situations into the skilled worker route. So really, unless you're here as a visitor, which you can't then switch inside the UK into permanent visa categories, then you can apply within the UK. So it used to be the case, for example, people who used to be here on a youth mobility visa. Youth mobility visas are for those people from certain countries. It allows them the ability to come to the UK for 2 years without the need for formal sponsorship by an employer, and just work for whoever in whatever job they wanted to. It was quite a flexible system. But at the end of that 2 years, they had to they had to leave the UK and to reapply for entry back into the UK under the Tier 2 category if they wanted to continue working. And that's no longer the case. And that's really a big advantage of the new rules, is the relaxation of switching requirements. So let's move on to the next slide. So how does this this new points-based system for post-Brexit immigration work? I'm going to get into the sort of nuts and bolts of this. I'm going to try not to overcomplicate it. Although I said that the system was kind of streamlined, there are some complications. And we'll see that most of those really relate to salary levels. But essentially, the basic requirement is for applicants to accumulate 70 points. 70 is the magic number. 50 of those are mandatory, as you can see from the slide. So you have to have a job offer from an approved sponsor. So you have to be on the list of sponsors if you want to sponsor someone. And the job has to be at a minimum of what's called RQF level 3. And that is, well, it used to be, again, it's another side of the relaxation of the immigration rules to a certain extent. It used to be degree level. So it used to be a fairly restricted category of jobs that you could sponsor people for. And that's been widened now. So the skill threshold has been reduced to A-level jobs. So that opens the field of potential jobs that you can sponsor people for much wider. And your starting point in identifying whether the job that you want to sponsor someone for is what's called appendix skilled occupations. That's a part of the immigration rules, which lists out all of the eligible jobs. And you've got to sort of go through that. We'll see that on subsequent slides. You've got to identify which job category the job fits into. So once you've passed the job offer from approved sponsor part of the rules, you also have to make sure that the appropriate minimum salary threshold is met. And as we'll see in a little bit later on, there are various things that you have to take into consideration to calculate exactly what the minimum salary would be for your role. And thirdly, as we've seen, English language. So that's one of the mandatory requirements, and you need to prove it in one of the mandated ways. And then the rest of the 20 points to get to 70 are what's called tradable. And really, it is those tradable points rely on either you meeting a certain salary threshold, or having a PhD, for example, that's relevant to your role, or being under a certain age, but perhaps a little bit later on in a couple of slides, we'll see exactly how that works. So if we move on to the next slide. So as I said, your starting point, appendix skilled occupations, and you've got to have a look at the eligible jobs, and you've got to consider whether the job specification that you want to sponsor the individual for is genuinely one that could be said to fall within the job category that you want to sponsor someone for. So there is a certain degree of assessment that you've got to do, a judgment call as to where the job fits into appendix skilled occupations, because that will determine also what minimum salary thresholds are relevant, are applicable to the particular job. Now, it used to be the case that the list of jobs that the Home Office included in the immigration rules included also a list of duties. So you could broadly, take a stab at where the job fell into, because you had that kind of feel for what kind of jobs, what kind of duties were included in each job category. But we don't have that anymore. All we've got is job titles. But what you can do is to go onto the Office of National Statistics website, and there is what's called an occupation coding tool, and you can either put the job code into that tool or the job title, and you can assess, it will allow you to assess exactly which job category it falls into. When I talk about job categories, it's the standard occupational classification code as developed by the Migration Advisory Committee. The Migration Advisory Committee is the committee that advises government on immigration policy, and every now and again it sort of refreshes the jobs that are eligible for sponsorship, and it's those jobs as determined by the Migration Advisory Committee that are included in appendix skilled occupations. So if we move on to the next slide, salary rates. So for each of those job codes, you have a number of different salary rates, and the Home Office bases salaries on a 39-hour week. So, well, the vast majority of jobs, there are certain jobs for which it will consider different hourly, different working weeks, but it will essentially calculate the salaries based on a 39-hour week. So you have to make sure that if there's a longer working week and you're near the kind of salary threshold, that if you're dividing your salary by, let's say, a 40-hour week and then timesing it by the 39-hour week that the Home Office is going to consider, that you don't fall below the relevant threshold. If you are working a 35-hour week, then you can prorate your salary accordingly, but it's always got to meet the general minimum salary threshold. And it's only basic salary that can be considered. So no even guaranteed allowances are, it used to be the case that you could include guaranteed allowances, but no more. It's only basic salary that you can consider. So let's move on to the next slide and see one of those occupation codes. So this is what European nationals are going to have to sort of deal with, I guess, to the extent that they don't have any basis for which to remain in the UK or to come to the UK. They are going to have a working knowledge, and their employers are as well, of what salary rates are going to apply if they need to be sponsored under the skilled worker route. So let's take, for example, if BDB Pitmans wanted to sponsor me as a chief executive, and I was a European, then they would firstly have a look in appendix skilled occupations, and they would determine that code 1115, as you can see there on the slide, that the job probably fell neatly into that, chief executives and senior officials. And then you can see a range of salaries, and that will depend on my circumstances. And if you can see the going rates there, so that's the minimum if I don't have a PhD or I'm not under the age of 26, then the going rate would be £67,300, and that's for a 39-hour week. So that's what my minimum salary would have to be. And you can see that the salaries reduce accordingly as you go across the different options: 60,570, 53, 840, etc., etc. You can see below that those options B, C, D, and E are in the case that you have a PhD in a subject relevant to the job, and provided that you meet a lower general salary threshold of 23,040, etc., etc. So, for example, option D, shortage occupation. If your role is in what has been determined by the Migration Advisory Committee, and there's a specific list of shortage occupations, then you would be subject to a different going rate and a lower general salary threshold. Obviously, in this case, chief executives, unfortunately, aren't on the list of shortage occupations, so this wouldn't be a viable option. Option E is for new entrants, and that relates to those who are under the age of 26. So obviously I would meet that requirement, and it has a lower salary threshold. So this is essentially the government recognizing that younger sponsored workers are earlier in their career, and they will have, you know, generally lower salaries reflecting that, and it's in order not to prejudice them as sponsored workers. They would have the ability to come to the UK on a slightly lower salary. Okay, if we can move on, I think, to the next slide. So one thing that EU nationals, when they apply for work as skilled workers, will need to bear in mind is that, okay, it's a fairly straightforward process, and really it's just English language. There are a couple of pitfalls. One of them is the financial requirement. So if you're applying for entry clearance from the EU or from anywhere in the world, you will have to show that you meet the financial requirement, and you will have to show, one of the options for satisfying that requirement is for you to show that you've held a certain level of funds, so £1,270 if it's just one applicant, for at least 28 days before the application date. And I don't know about you, but my bank balance certainly fell below that within the last 28 days. So it can be problematic, because even one day when the balance is below the magic threshold would lead to an application failing. And often the easiest thing to do is for the sponsor to actually certify maintenance, and it does that by basically ticking a box on the sponsor certificate, and it removes the need for the individual to provide any financial documentation at all as part of their application. Just in practical terms, you know, it's obviously been a difficult period in order to make any kind of visa application anywhere in the world, given the COVID pandemic. And indeed, well, there were points last year when the whole system simply wasn't functioning at all. And what we have now is largely a return to some kind of normality in the UK and around the world. The priority service for quicker processing of applications has kind of restarted in most locations around the world now. So it is gradually getting back to normal. What I would say is that the Home Office, for obvious reasons, I guess, because of Brexit, is under a certain amount of pressure, both in terms of sponsor licenses, processing those sponsor license applications, and also processing visas and bringing out appointments for people to attend both in the UK and overseas. So there may be delays in the backlog for that reason. Quickly, I'll mention the settlement salary threshold. It used to be the case that you not only had to meet all of those salary criteria, which we've just seen, but that you would also have to meet a different higher salary threshold for settlement, regardless of the going rate for your role. But that's been removed. All you would need to concentrate now as an applicant in order to then settle are those minimum rates for your particular job code. So that's a particularly useful development. Moving on to the next slide, what I've done is to kind of go through and give you an indication of the cost. And this is, I think, probably an area where EU nationals are used to the benefits of free movement, or the prospect that they would be able to come to the UK, and obviously for UK nationals going abroad to live and work as well, it's going to be the same issue. The primary consideration will be one of cost. And I've written down a bit of an example here. So MICO Limited, a software engineering firm, let's say, and they want to sponsor Marie, forgive my French accent, in a business development role. And so she's French and resident in France, and Myco have advertised in the UK. They haven't been able to find anyone. Marie answered the advert. She's perfect. She has a great understanding of Myco's market, and so they want to sponsor her. Now, luckily, Myco already a licensed sponsor, so it doesn't have to go through any of that process before it sponsors her. But what it will need to do is pay the figures that are there. So £199 to assign what's a defined certificate to Marie, and then an immigration skills charge to sponsor her. So it's £1,000 per year of leave for that initial 3-year period of her work in the UK. So that's an initial investment of £3,199. And Marie, for her part, once she's got the certificate, will then need to apply for a visa. And she's married and has 2 children, for example. And there is an indication of the fees that are currently applicable to Marie and her family. So she has to pay an application fee. She has to pay an application fee for also the members of her family. And she also has to pay an immigration health surcharge. Now, this is quite a controversial charge. Controversial primarily because it costs so much. I mean, it used to cost, I think, £200 per year of leave, and that's increased to now £624 for adult applicants. So it's quite a significant amount of money, particularly as people pay for it, arguably through taxation anyway. It became particularly controversial during last year's lockdown, when it became apparent that healthcare professionals were having to basically pay an immigration health surcharge at a time of crisis when they were working in the health service, and that's been removed, as we'll see slightly later on. So, immigration health surcharge of quite significant amounts for her and her family, and that would lead her to paying an initial fee of some £9,000 for entry clearance to the UK. So if we move on to the next slide, we'll have a look at the costs going forward for Marie and for Myco. So let's assume that the job goes well for Marie, and Myco want to sponsor her for a further 2-year period, let's say, to get her to settlement, the sort of 5-year threshold for her to apply for settlement. So Myco pays, again, that £199 to assign the certificate to her, and that £2,000 immigration skills charge. So that's £1,000 per year of leave, and that's a further investment for Myco of £2,199. And Marie, still married with 2 children, then extends her visa, and she'll pay the fees that you can see there. So it's a £704 application fee, and none of this is priority. This is standard processing. You can pay more for priority processing, and an immigration health surcharge for her and her family members. And I've included a biometric enrolment fee there as well, which is £19.20. So you're looking at a sort of follow-on investment from Marie of just over £7,000 in order to extend her visa for her and her family. So let's look now on the next slide at settlement. So after 5 years, Marie wants to settle in the UK. The job's going well. Children are still in school. The family have thrown down roots. And this is what Marie would have to pay for settlement. So it is an application fee of £2,389 for herself and each of her family members. And you're looking at about £9,500. And it goes without saying that the grand totals for Marie and Myco are quite a few beers. It's quite a significant amount of money, and it's a significant investment, probably less so for Myco, which might just treat it as a running expense for operating a business in the UK, but it is quite an investment for Marie and her family. Now, many employers may take the approach that part of that will be paid on on the applicant's behalf, but there is no obligation to do so. So it is quite a significant amount of money. So let's go on to the next slide. So applying for a license, it's a fairly straightforward process. Obviously, I think a lot of employers particularly are sort of waking up to the fact that in order to resource their recruitment needs sufficiently, they will have to get a sponsor license if they haven't already got one. And it's relatively inexpensive to apply for. So it's £1,476 for medium and large size businesses. And then of course, we've seen the cost of sponsorship that Myco had to incur during the life of sponsorship. So depending on the size of business, you know, it could be a relatively small part of the operational cost of running a business. And in order to apply for a license, you have to go through an application process and provide a number of different documents showing that your business is operational, up and running, and the Home Office then goes off and considers that paperwork and decides whether or not to give you a license. And it normally, well, it has taken a very short period of time in which for that to come through. So typically, a couple of years ago, it would take 1 or 2 weeks. And I guess, again, as a result of Brexit, the time taken to get a sponsor license in place and for the Home Office to approve that has increased significantly. I think the time frame is still 6 to 8 weeks officially, but there is now a process whereby that application can be expedited in return for a payment of £500. The problem is actually being accepted for the expedited service, because I think it's only 10 applications per day that will be accepted for the quick service. So it's actually quite difficult to get onto. And once you get accepted onto that, within 10 working days, that's the turnaround time for granting or deciding the application. And you may be visited by a pre-compliance officer who sort of comes into your premises and determines whether you're, you know, whether you're going to be a good sponsor and comply with your sponsorship duties and prevent illegal working. They might ask you about the jobs that you want to sponsor people for, and lots of sort of different areas which they have to run through in order to be satisfied that you are going to be a good sponsor. I've mentioned key personnel. If you're going to sponsor EU nationals and you're going to get a sponsor license, you're going to have to nominate certain people for certain roles. So an authorizing officer is kind of a presidential position where it's basically the person with overarching responsibility for the sponsor license, and that has to be the sort of most senior person responsible for recruitment within your organization. And they would have to be present during compliance visits. They have to give certain authorization when you make a request through the sponsor management system. So it's kind of that senior role. And then you have level 1 users who are your administrative people who will have access to what's called the sponsor management system, which is the portal which provides the interface between the Home Office and licensed sponsors. And level 1 users are responsible for issuing certificates, applying for certificates, and things like reporting duties. So we'll go on to see a number of those in a moment, but they're the people who kind of do the admin side of the sponsorship system. And you can nominate external representatives. So we act for a number of companies in the level 1 usership capacity. So you can nominate external parties into that role, but not into your authorizing officer role. And so we've covered compliance visits. So if we move on to the next slide, there are a number of sort of requirements that you'll have to comply with as a licensed sponsor. And there are certain documents which you need to keep that's all outlined in what's called Appendix D. And if you were ever compliance visited, they would want to know that you knew about this this guidance, or the Appendix D keeping documents guidance, because otherwise you wouldn't necessarily be aware of your responsibilities of what documentation you've got to keep in relation to sponsored workers. And another important document over on the right there is the general guidance on sponsor duties and compliance, and that contains a run through really of what reporting duties you have as a sponsor. And I guess that's the important takeaway here, that if you are applying for a license to sponsor EU or workers from other parts of the world, you will not only have to get a sponsor license, but you'll have to keep it. And that requires you to comply with lots of reporting duties, as I say, outlined in the sponsor duties and compliance guidance. Things like reporting changes to salary, reporting changes to duties, if people are absent without leave, changes to corporate structure. I mean, that's something that frequently catches out sponsors, that if there are any corporate ownership changes, so if you get taken over, then there are reporting requirements, and there may even be a need to apply for a wholly new license, even if the corporate structure change is relatively nominal and has been done for sort of good housekeeping from a corporate standpoint. Also, changes to key personnel, that's something that frequently falls by the wayside. If you change level 1 users, if they move on, then you've got to report that. And the authorizing officer, if they move on, that's got to be reported, and you have to have a nominated authorizing officer at all times, and a level 1 user that is an employee or office holder of your organization. So just very quickly, okay, so we've seen some of the duties of compliance. If we move on to the next slide, I think we've discussed that already quite a bit. So I think, yeah, it's just basically to be aware of your duties, your reporting duties as a sponsor, and to retain certain documents as per Appendix D that we saw on the previous slide. So let's move on to the next slide. I guess really the headline is that if, to the extent that the Home Office concludes that you aren't, perhaps through a compliance visit or other investigations that it undertakes, if it concludes that you aren't a good sponsor, then of course, or you have employed people illegally, then the sanctions can be quite swingeing. And of course, the headline, which I'm sure you're all aware of, is the £20,000 potential fine per illegal worker that they identify. So if someone hasn't got the right to work and you haven't done the correct right to work check, then that's quite a significant penalty to have to pay. And there's also the prospect that your license could either be suspended or downgraded or completely revoked. Now, in the new Brexit landscape, losing a license is probably going to have much more of an impact on your business than it might otherwise have done previously. So once you have applied for that license, taking your compliance duties very seriously as a sponsor is definitely the way to go. And of course, you know, reputational damage is an incredibly large part of that too. Okay, let's move on to the next slide, which is other categories. So we've talked lots about how European nationals can come to the UK under the sponsored work category. I'll just highlight a few of the other changes to the immigration rules, some of which are Brexit dependent or have happened as a result of Brexit. Now, of course, we have this health and care visa, as I mentioned earlier on. It's a relaxation of the immigration rules for health and care visas. So it's for those with a confirmed job offer in one of a number of defined healthcare professions for the NHS, or for those companies that are commissioned by the NHS as service providers. And it basically allows applicants to have fast track entry. It's a cheaper application fee, and dedicated application support. So that health and care visa applicants also don't have to pay the immigration health surcharge, which is obviously a very welcome development for those applying for this visa. Visitor visas largely unchanged. I think we're going to come on to sort of frontier workers in just a moment. We're kind of running out of time, but startup and innovator visas, again, they're quite restrictive. They require endorsement. So if you're looking to start up a business, it's basically weighing up whether this is really a viable option for you, or whether the skilled worker sponsorship route is going to be the best way forward. Graduate visa route. This is the return of the post-study work category, which was abolished a few years ago. They're bringing it back in. So if you do a degree in the UK, obviously this relates to not just European Union nationals going forward, but most of whom will, as of now, have been resident in the UK before the 31st of December 2020 anyway. But going forward, graduates will be able to remain in the UK for 2 years after completing their degree, or 3 years for PhD holders. A very brief mention of the UK-India migration agreement, which is, I think, just a couple of weeks ago, which was agreed in outline, and it will allow at some point in the future Indian nationals to come to the UK in a kind of youth mobility format. So it's a restricted period of, I think, 2 years when they can basically come to the UK. Indian nationals of a certain age can come to the UK for work. So it's basically an expansion of the youth mobility visa, and it's a sign that, as we suspected, I guess, that trade agreements with other countries, as in the wake of Brexit, may well entail changes to the immigration rules for certain nationals. And I guess it remains to be seen with quite some interest as to whether this will also be the situation when we come to negotiate trade agreements with other countries. Let's move on to the next slide, which is the EU-UK Trade and Cooperation Agreement. A very quick mention. Basically, it is possible that if your staff are delivering services overseas, and likewise for those companies in the EU wanting to deliver services to the UK, it's possible that you could come within the contractual service provider or independent professionals provisions of the EU-UK Trade and Cooperation Agreement, subject to your compliance or your employees' compliance with the requirements that I've listed out there. And what you would need to do, if you think that this is possible, is to basically have a look through the annex serving provisions to see which sector you want to provide services in, and assess, because there are lots of country exceptions and additional requirements that are put on by certain countries that limits the ability of contractual service providers and independent professionals to offer their services for a limited period and to send UK nationals to those EU countries in order to perform those services. So similarly, for those EU companies that are sending individuals to the UK, that would be under what's called the International Agreement immigration category, and it still needs a UK sponsor to sponsor those individuals into the UK. Lastly, frontier worker permits. So this is another, I guess, visa option if EU nationals are not entitled to settled status or pre-settled status. It may be the case that actually a frontier worker permit is viable, and essentially it's for those who are living outside of the UK. So if we move on to the next slide, Melissa, it's basically for those who are living outside of the UK, for people who must have started working in the UK while still living elsewhere by the end of the transition period, by the 31st of December 2020, and they must be either present in the UK for less than 180 days in any 12-month period, or they must have returned to their country of residence once every 6 months or twice in 12 months. And I guess it's probably a restricted category of person that would be eligible for a frontier worker permit, but it's certainly something to consider in the overall sort of range of visa options which you might need to consider as an EU national. So we've kind of, that's kind of a broad introduction to the immigration system post-Brexit. What I would suggest is that we have a few questions. In order to, it's probably best actually if we have a look at those questions. What I will do is do the best that I can to answer them in the follow-up. What we're going to do is send out the slides and the recording to participants, and what we will do is try and answer those questions as well, so that we keep to time. So thank you very much for everyone who's been on the webinar. We hope it's been of use, and we will see you in the very near future for the next instalment of the Brexit webinar series. Thank you very much.